Dear friends, evidentiary value of confession is the subject today. In this slide show, I am going to discuss about the relevancy and probative value of confession of an accused in a criminal trial. I most welcome all of you to this slide show. Thank you very much for having visited this slide show. Before proceeding to the topic, I want to read section 24 to 27 and 30 of Indian Evidence Act. Section 24 speaks about confession caused by inducement, threat or promise when irrelevant in criminal proceeding. If confession is appeared to have been made due to inducement, threat or promise, they are irrelevant in criminal proceeding. Section 25 is the confession to police officer not to be proved. No confession made to a police officer shall be proved as against a person accused of any offence. Section 26 says, confession by accused while in custody of police not to be proved. No confession made by any person while he is in the custody of a police officer, unless it be made in the immediate presence of a magistrate, shall be proved as against such person. So, confession made by an accused when he is in custody of the police officer is inadmissible. Section 27 starts with provided that. So, it is a proviso clause. How much of information received from accused may be proved, provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. The term confession has not been defined in the Indian Evidence Act. AR 1966 Supreme Court, page 40. A confession is nothing but an acknowledgment of guilt in express words. A confession is a statement made by an accused which must either admit in terms of the offence or at the rate substantially all the facts constituting the offence. Pakala Narayana Swami vs Emperor, AR 1939, Privy Council 47. Sections 24 to 27 and 30 of Evidence Act is relevant to the topic. Section 25, confession to police officer not to be proved. Confession by accused when he is in custody of the police need not be proved against him, because confession before police officer is inadmissible. Related judgment, AR 2011 Supreme Court 2490, AIR 1966 Supreme Court 119, 1997 Criminal Law Journal 1566. Section 27 is an exception to sections 24 to 26. 2004 Criminal Law Journal 1380 Supreme Court. Section 27 starts with provided that. So it is a proviso clause to section 24 to 26. In order to apply section 27 of Indian Evidence Act, the prosecution has to prove the 6 ingredients. Number 1, there must be some accusation against the accused. The accused must be in custody of police officer. There must be some information by the accused. The information may be confession or statement. There must be discovery of fact from the statement of accused. The discovery must be distinct one, and the distinct recovery must be relevant to the case on hand. AIR 1983 Supreme Court, page 446. AIR 1960 Supreme Court, 1125. It is not all recoveries are admissible. The relevant discovery is alone admissible into evidence. 2017 1 Madras Weekly Notes Criminal 62. 2017 3 SCC page 832. 1969 2 SCC 872. In section 27, the word police officer has been coined. In custody of a police officer has been used in section 27. So, we must know who is police officer. The word police officer has not been defined, but it is settled that the expression should not be confined to police officer. Section 1 of the Police Act is relevant. Police officer who has got right to file final report under section 173 2 CRPC can be considered as the police officer for the purpose of interpreting section 27 of Evidence Act. 1991 Criminal Law Journal, page 97 Supreme Court. 2017 Volume 3 Madras Weekly Notes Criminal, page 355. AIR 1970 Supreme Court, 1065. In section 27, the following words are used: whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered may be proved. As relates means the discovery of fact must be relevant to the case on hand. All the discoveries at the instance of accused are not admissible into evidence. If discovery of fact relates to the charge against the accused, then only the discovery is admissible into evidence. 2017 Volume 3 SCC Criminal, page 832. 2013 Volume 1 MLJ Criminal, 435. 2013 1 Law Weekly Criminal, page 633. 2011 Volume 3 SCC Criminal, page 620. One of the ingredient to invoke section 27 of Evidence Act is custody and not arrest. The accused must be in custody of the police officer, and the accused need not be under arrest of the police officer. Culpable homicide and murder, like the same, arrest and custody. In murder, there will be a culpable homicide, but not vice versa. In every arrest, there will be a custody and not vice versa. There is a remarkable distinction between police custody and arrest by police. The term arrest has been defined in section 41 of CRPC, but what is meant by custody has not been defined in the Code of Criminal Procedure. Arrest is a mode of formally taking a person into police custody, but a man may be in police custody in other ways. The word in custody used in section 27 of Evidence Act only denotes surveillance or restriction on the movements of the person concerned. 1969 MLJ Criminal, 765. 1970 Criminal Law Journal, page 325. The word whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered may be proved, has been coined in section 27. What is the meaning of distinct discovery? In pursuance of the statement of an accused, dead body was discovered. The said statement was already in FIR. Section 27 is not retracted. The word distinctly means directly, indubitably, strictly, unmistakably. Section 302 IPC fact discovered, disclosure statement, 1985 Criminal Law Journal, page 1416, AR 2004 Supreme Court, page 2865, 2017 3 SCC Criminal, page 343, 2004 10 SCC, page 657. Confession before judicial officer is known as judicial confession. Judicial confession, extrajudicial confession, and confession before police officer are the three types of confession. Section 164 CRPC defines judicial confession. 164(2). It must be explained to the accused that he is not bound to give confession. A duty is cast upon to the learned judicial magistrate. The learned judicial magistrate has to explain to the accused that he is not bound to give confession. If confession is given, that will be used against him, and the learned magistrate has to find out by questioning him whether the confession is voluntarily made or not. Section 164(3). After accused not ready or unwilling to give confession, there shall not be police custody. 164 subclass 4. The learned magistrate, after recording the confession of an accused, has to prepare a memorandum at the foot of confession as contemplated under section 164(4) CRPC and shall not administer oath. AIR 1978 Supreme Court 1574, 2011 2 SCC 490. The following are the points to be borne in mind at the time of recording confession by the judicial officer under section 164 CRPC. 1. That he is not bound to make confession. If he gives confession, the same will be used against him. The learned judicial magistrate has to satisfy himself that the confession has been made voluntarily. If the person is not willing to make confession, the learned magistrate shall not detain him under the police custody. The learned judicial magistrate has to make a memorandum at the foot of confession as contemplated under subsection 4 of section 164. Before recording confession, the learned magistrate has to bear in mind the principles given by the Honorable Apex Court. At the time of recording confession of an accused, the learned judicial magistrate shall not administer oath. Section 164, subclass 5 CRPC. Chandran case is the leading case. AR 1978 Supreme Court, page 1574, 2011 2 SCC, page 490, para 64. The learned judicial magistrate, by putting questions to the accused, can easily find out whether the confession is voluntarily made or not. The judicial magistrate has to find out whether the confession has been given voluntarily or not. The learned judicial magistrate ought to have put leading questions, but it should not be like a cross-examination AR 1977 Supreme Court 1579. Before recording the confession of an accused, the learned magistrate has to give reasonable time to the accused. The reflection time to the accused is mandatory. 1994 SCC Criminal, page 899. An interesting question can be raised: whether executive magistrate can record confession under section 164 CRPC. The term magistrate used in section 164 CRPC is clearly judicial magistrate and not the executive magistrate. Hence, confession under section 164 CRPC, that is judicial confession, can be recorded only by the judicial magistrate and it cannot be recorded by the executive magistrate. AR 2000 Supreme Court 2901. If a confession is recorded other than the judicial officer, it is known as extrajudicial confession. An extrajudicial confession is a very weak piece of evidence. Normally by itself, it can be corroborative only. AR 1952 Supreme Court, page 159. 1995 Criminal Law Journal, page 248. Extrajudicial confession. Siva Subramanian and others. Decided by Madurai Bench of Madras High Court. Reported in Law Weekly Criminal, MLJ Criminal, 2019. This is a case of triple murder. The extrajudicial confession is a very weak evidence by itself. It has to be examined by the court with great care and caution. It should be made voluntarily and should be trustful. It should inspire the confidence of the court. Extrajudicial confession attains greater credibility and evidentiary value if it is supported by a chain of cogent circumstances and is further corroborated by other prosecution evidences. In order to record conviction on the basis of an extrajudicial confession, it should not suffer from any material discrepancies and inherent improbabilities. Such statement essentially has to be provided like any other fact and in accordance with law. Confession of co-accused. The confession of co-accused has got its own importance in appreciating the evidence. Section 30 of Evidence Act is relevant. All the accused must stand in a joint trial. Then only confession of co-accused can be taken into consideration. Kashmira Singh vs State of Madhya Pradesh is the leading judgment. AR 1952 Supreme Court, page 159. 2017 1 Madras Weekly Notes Criminal 62. 2017 2 Madras Weekly Notes Criminal 338. With regard to confession and discovery, 3 judgments are relevant, important. 2019 3 MLJ Criminal 129. 2019 2 Madras Weekly Notes Criminal 487. 2019 Volume 2 Law Weekly Criminal, page 877.